Presentation on Indian Partnership Act and Limited Liability Partnership Act. Indian Partnership Act studied under 6 heads: nature, rights, duties, formation, reconstitution and dissolution. Nature of partnership. Partnership is a relation between persons who have agreed to share the profits of a business, the business carried on by all or any of them while acting for all. Mere receipt of a share in the profits of a partnership firm doesn't make a person a partner. To become a partner, one has to be a part of the partnership agreement. Parties to a partnership agreement are individually called partners and collectively they are called a firm. Firm name is the name under which the business of the partnership is carried on. Whether a person is a partner or not is decided by looking into the real relationship between the parties under the contract. Where the contract between partners provides for the duration of partnership or the end point for determination of the partnership, such a partnership is called partnership for a fixed term. Where the contract of partnership doesn't provide for the duration of partnership or it doesn't indicate the point of determination of the partnership, and even where it specifies the duration, if the partners continue their business even after the duration, in both cases the partnership will be known as partnership at will. A partnership which is formed for a particular adventure or undertaking, and at the completion of the said venture or activity the partnership is dissolved, such a partnership is known as particular partnership. Where the scope of the business of a partnership is not defined and it is to carry out business in general, such a partnership is called general partnership. Partners, 5 types: working partner, sleeping partner, limited partner, partner in profits and nominal partner. Contribution of capital comes from everyone except nominal partner. Participation in the management largely by the working partner. Partner in profits shares only profits. Nominal partner doesn't share profits or losses. The remaining 3 share profits or losses. Liability is limited in respect of limited partner. In all other cases it is unlimited. To the outside world, partners who are known and visible are working partner and nominal partner. The mutual rights of partners is decided by the terms of partnership. For participation in the conduct of business, partners are not eligible for any remuneration. Unless the contract states otherwise, partners share both profits and losses equally. Where the partnership deed talks of interest on capital, such interest can be paid only when the partnership makes profits, as it has to be paid only out of profits of the firm. An interest of 6% per annum is payable to a partner who makes payment or advance beyond the amount of capital. He will also be indemnified for payments made or liabilities incurred, provided it is incurred in the proper conduct of business for protecting the firm from loss, and it was done under circumstances as would be done by a person of ordinary prudence. Similarly, a partner is obliged to indemnify the firm for any loss caused by his willful neglect in the conduct of the business of the firm. Among the duties of partners, the general duty to carry on the business to the greatest common advantage, to be just and faithful to each other, and render true accounts and full information with transparency. For all losses caused to the firm due to fraud or negligence, a partner shall indemnify the firm. Although it is partners' right to participate in business, it all depends on the express or implied contract between the partners. In the normal course, a partnership may provide that a partner shall not carry on any business other than that of the firm. He has got a right to take part in the conduct of business. He is bound to attend diligently to his duties. Any difference in a business is decided by majority vote, and every partner has got a right to access and inspect and take a copy of the books of of account. It's a duty of every partner to use the property of the firm exclusively for the purpose of the business. If he derives any profits for himself, he shall account and pay it to the firm. If he carries on a business competing with the firm, he shall pay to the firm all profits of that business. When a change happens in a firm and it is reconstituted, mutual rights of partners remains the same, and if a partnership firm continues after its duration, the mutual rights and duties of partners will be as if it is a partnership at will. The office of the registrar of firms is relevant for formation of a partnership. Registrars are appointed by state governments and their areas are defined. An application for registration is submitted to the registrar along with details of firm name, places of business, names and address of partners, and duration of the firm. Each person signing the statement will verify in the prescribed manner, and the firm name shall be in conformity with the approval of the registrar of firm. Once the registrar finds the application to be in conformity with section 58, he will record an entry in the register and the firm is registered, and it is the duty of the firm to file alterations subsequent to registration, be it in firm name, place of business, branches, or names and addresses of partners, or anything pertaining to dissolution of the firm. Non-registration of a firm creates disabilities for the firm and its partners. Where a firm is not registered, no suit can be filed on behalf of a partner against the firm or other partners, and also on behalf of the firm, no suit can be filed against any third party. But non-registration will not affect the right of a partner to sue for dissolution or to sue for accounts of a dissolved firm or to realize property of an insolvent partner. Under Reconstitution, there can be admission of a partner subject to consent of all existing partners and the new partner liable for acts done after he became a partner. Retirement is permitted with the consent of all partners or as per the express agreement by the partners, or where the partnership is at will by giving a notice in writing to all partners of his intention to retire, but he continues to be liable to third parties for any act done till his public notice is published. Reconstitution includes expulsion of a partner in good faith and in terms of powers confirmed by contract. An expelled partner will be covered by section 32 as if he is a retired partner. In respect of insolvency of a partner, he ceases to be a partner on the date adjudicated as insolvent, but his estate not liable for acts done after that date. In respect of a deceased partner, his estate will not be liable for acts done after the date of demise. An outgoing partner, be it retiring partner or an expelled partner, can carry on a competing business, but he shouldn't use the firm name or solicit business from persons dealing with the firm. The firm can enter into an agreement with him not to carry on similar business within a specified period or specified area, provided the restrictions are reasonable. If he has given a continuing guarantee, it shall be revoked as to future transactions. And the continuing partners, if they carry on business without final settlement of the outgoing partner, the outgoing partner is entitled to his share of profits attributable to the property belonging to him in the firm, or he is eligible for interest at the rate of 6% per annum. Dissolution of a partnership is permitted by agreement when, with the consent of all partners, it can be dissolved, or it is required to be dissolved compulsorily when all but one or all partners are adjudged insolvent, or the business of the firm is rendered unlawful on the happening of any event. And other than this compulsory dissolution, if it is a partnership at will, it can be dissolved by way of notice from one of the partners giving a notice in writing of his intention to dissolve, and the dissolution takes place based on the date indicated in the notice, if date is not indicated, from the date of submission of the notice. Under section 44, court can dissolve a firm on various grounds. One of the grounds is a partner has become of unsound mind, or a partner has become incapable of performing his duties on a permanent basis, or a partner is guilty of conduct which is likely to prejudicially affect the conduct of business, or a partner willfully commits breach of agreements and it is not practicable to carry on business anymore, or the business of the firm cannot be carried on except at a loss or any other just and equitable basis, the court is convinced that the firm should be dissolved. Under normal circumstances, dissolution also takes place in respect of partnership for a specific period by the expiry of that period, in respect of a partnership for a particular adventure on the completion of that adventure, or by the death of a partner, or by the adjudication of a partner as an insolvent, all these in the normal course. Even after dissolution, partners continue to be liable to third parties until public notice is issued. Partners are entitled to have the business wound up, pay the debts and liabilities, and get the surplus distributed among themselves. The property of any partner is first applied in payment of his personal debts. Surplus only will be available for payment of firm's debts, and the firm's priority will be losses paid out of profits, then out of capital, and lastly by contribution from partners in the profit sharing ratio. Assets of the firm are distributed in the order of debts of the firm to third parties, followed by return of advances from partners, then return of capital, and if residual surplus comes, it will be distributed to partners in the profit sharing ratio. Section 54 provides that the partners, upon dissolution or in anticipation of dissolution, can make an agreement that some or all of them will not carry on a business similar to that of the firm within a specified period or within a specified local limits, and such agreement shall be valid if the restrictions imposed are reasonable. This is notwithstanding anything contained in Section 27 of the Indian Contract Act on contracts in restraint of trade. As regards relation of partners to third parties, a partner is an agent of the firm for the purposes of the firm's business. The act of a partner binds the firm, and this authority to bind the firm as an agent is called implied authority. But the implied authority doesn't include right to submit a dispute to arbitration, open a firm's bank account, or relinquish any claim, or withdraw a suit filed in a court, or acquire or transfer immovable property on behalf of the firm. In a relationship of agency, any notice to a partner operates as a notice to the firm, except in case where fraud is involved by the partner. Every partner is liable jointly with other partners and also severally for all acts of the firm done while he is a partner, whereby the wrongful act or omission of a partner in the conduct of business, loss or injury is caused to any third party, both the partner and the firm jointly and severally liable to the third party. Section 30 deals with the minors and partnership. Minors may be admitted to the benefits of a partnership with the consent of all partners, but a minor cannot be a partner himself. He may have access to and inspect and take copies of any of the accounts of the firm. Minor's share is liable, but minor is not personally liable for any acts of the firm. On attaining majority within 6 months, he may give public notice that he has elected to become or not to become a partner. If he fails to give such notice, he becomes a partner on expiry of the said 6 months. On attaining majority when he becomes a partner, his rights and liabilities continue as a minor up to the date on which he becomes a partner. He becomes personally liable for all acts of the firm to third parties since he was admitted to the benefits. His share shall be the share to which he was entitled as a minor, with no change, and where he elects not to become a partner, his rights and liabilities continue to be those of a minor up to the date of public notice, and he shall not be liable for any acts of the firm done after the date of the notice. Limited Liability Partnership Act 2008, studied under Meaning and Features, Incorporation, Liability of Partners, Accounts and Audit Provisions, Conversion into LLP, and winding up. The concept of LLP, Limited Liability Partnership, gives the flexibility of a partnership and a separate legal entity. It is a partnership formed under LLP Act, which defines mutual rights of LLP and partners. The number of members required to form an LLP, minimum 2. They can be individuals, LLPs and a company, but members cannot be cooperative society or any other body corporate. LLP Act provides for designated partners who are responsible for ensuring compliances. They should be individuals. 2 designated partners are required, may include representatives of body corporate. At least one of them should stay in India for a minimum of 120 days during a financial year. The consent of a DP is filed in Form 9 and particulars of a designated partner are filed in Form 4. Foreign LLP is one which is registered outside India but having a place of business in India. It is required to state legibly in all its invoices and correspondence that it happens to be a foreign LLP. The first step in the incorporation is reservation of name, which will be reserved if available up to 3 months after intimation by the registrar, and during the period, submission of incorporation documents with the details of 2 or more subscribers furnished with the capital-based fee payment for certificate with the LLP in issued within 14 days. Details of registered office also submitted as address for all communications. As an effect of registration, an LLP becomes eligible to sue and be sued. It can acquire and dispose property in its own name, and it can act as a body corporate using its common seal, and its name could be changed with the consent of requisite members, or when the government directs the name to be changed, it has to be done within 3 months. On change of name, fresh certificate will be issued and the new details has to be used in all subsequent correspondence. LLPs have the privilege of changing their registered office within the territory of the registrar or within the state or interstate. There is a requirement of 21 days notice in a vernacular and English daily, more particularly in respect of interstate movement. Consent of secured creditors required to be obtained, and also filing with the necessary details required to be done at registrar within a period of 30 days. An agreement between subscribers defines the relationship between partners. It has to be ratified by all partners within 30 days of incorporation and filed 30 days thereafter. Any changes also to be filed within a period of 30 days. If there is no agreement formally filed, first schedule to the Act applies. As for liability, cessation of partnership interest can happen as per agreement, or it can be on the death of a partner, or on dissolution of LLP, or based on a court order in the event of insolvency or unsound mind. As regards entitlement of an outgoing partner, he will get proportionate capital, accumulated profits net of losses, and a share in profit or loss till the notice of ceasing to be a partner. As regards the change in partners and their particulars, names and addresses change. Partners have to indicate LLP in 15 days and LLP to inform registrar within next 30 days. And outgoing partners and new partners can inform registrar directly, or they can inform through the LLP. LLP as a principle is liable for all authorized acts of partners in the course of business. Every partner is an agent of LLP. He is not an agent of other partners. As an agent of LLP, he is liable for all wrongful acts of his and his acts to defraud creditors, if any. A partner is required to contribute as per LLP agreement. The Act provides for maintenance of books and accounts for each year on receipts, expenditure, assets and liabilities. Books to be preserved for 8 years after the year end. As for statement of accounts and solvency, they are to be signed by designated partners, filed within 30 days. After 6 months from year end, they are made available for public inspection. Audit is mandatory in respect of an LLP where its turnover is more than rupees 40 lakhs or its capital contribution is greater than 25 lakhs. The auditor has to be appointed at least 30 days before year end, and his reappointment, removal, resignation or treatment of casual vacancy will be as per terms indicated in the LLP agreement. An LLP's annual return has to be signed by a company secretary where the turnover exceeds rupees 5 crores or the contribution of capital is greater than rupees 50 lakhs. It will be available for public inspection and shall be signed by a designated partner. As regards preservation of records, incorporation document, LLP agreement and notice of situation are permanent documents to be preserved, and as regards liquidation accounts, they shall be preserved for 21 years, and as for other papers, the duration ranges between 3 years and 5 years as specified item wise in the Act. Registrar has the power to summon and seek details from partners, designated partners and employees, both past and present. LLP Act provides for creation of LLP by conversion of firm. Only existing partners can convert into an LLP by way of transfer of assets and liabilities from firm into the new LLP. The firm shall apply to registrar with incorporation documents and statements by all partners. If the registrar refuses, the firm can appeal to tribunal. Just like firms, even private limited companies can convert themselves into LLP, but they shall comprise all shareholders and none else. The company shall apply to registrar with incorporation document and statements by all shareholders and can appeal to tribunal if registration is refused. Public companies which are not listed on any stock exchanges, means unlisted public companies, are permitted to be converted into an LLP, once again comprising all shareholders and none else, using the same process, and can appeal to tribunal if the registration is refused. Conversion has essential effects and requirements. An LLP to inform ROC within 15 days that all property and whole undertaking vests in LLP. The erstwhile entity will be dissolved and removed from register of firms or companies. All pending proceedings are continued by or against the new LLP. Conviction, ruling, judgment will be enforced against LLP. 12 months from registration, every correspondence from the LLP shall state converted into LLP from the name and registration of the converted entity. A voluntary winding up under the winding up process involves essential steps like resolution to wind up, obtaining approval of creditors subsequently, declaration of solvency and publication of newspaper notice to that effect, followed by appointment of liquidator, getting the report of liquidator to partners and creditors for 2/3 approval within 30 days, winding up report to be filed with the registrar within 15 days, and then apply to tribunal to order dissolution of LLP. LLP to file tribunal order with the registrar within 30 days, and the gazette notification from the registrar will be the final step to ensure the LLP stands dissolved. LLP liquidator is quite crucial for the process of winding up. He is required to file disclosure of conflict of interest on appointment and during every stage of the assignment. He may be removed by tribunal on application from registrar or by the appointing partners or creditors. After notice and hearing, he is required to maintain register and proper books of account, and the accounts shall be audited. The liquidator may include the views of partners and designated persons in his report to the tribunal. Winding up by tribunal ensues based on petition from LLP, partners or creditors, and the registrar will obtain central government approval on the ground that the LLP is unable to pay based on declaration of solvency. It will direct LLP to file objection, proceed with appointment of liquidator, and the liquidator will submit the report within 60 days and proceed with taking custody of assets. Subsequent to taking possession of the assets, tribunal will appoint a sale committee with action for rehabilitation if relevant. Periodic reports of liquidator will be submitted to the registrar. Winding up report will be filed with the registrar within 15 days, and it will be followed up with application to tribunal to order dissolution of LLP. LLP stands dissolved once winding up tribunal order is filed with the registrar. Anyone aggrieved can appeal to appellate tribunal within 45 days of order. A comparison by feature between partnership, LLP and company. Legal entity, both company and LLP are separate legal entities. A partnership is not. Liability, for partners, liability is unlimited. Liability is limited for members of LLP and members of a limited company. Number of members, minimum 2 and maximum 100 for a partnership. Minimum 2, no upper limit for LLP. Minimum 2 for private, minimum 7 for public, maximum 200 for private, and no upper limit for public limited company. Primary governing law, Indian Partnership Act for partnership, LLP Act 2008 for LLP, Companies Act 2013 for company. Transfer of shares need consent of other members in partnership as per agreement between subscribers in LLP, freely transferable in a public limited company. Management by any or all partners in a partnership, by any or all members in an LLP, by board of directors in a limited company. Relationship between members of agency between partners in partnership. Agency with LLP in LLP, no agency relationship in a company. Profit distribution as per agreement between partners in a partnership firm, as per agreement between subscribers in LLP, dividend as declared by the company. Remedy to creditors against partners jointly and severally in partnership. In LLP, it is only against LLP, not its members. In case of company, only against company, not against its members. Audit, simple compliance in partnership. Turnover and capital linked mandatory audit in LLP. Mandatory audit compliance required in a joint stock company. Dissolution of a partnership is based on an agreement, death, retirement of a partner, as per provisions of LLP Act in respect of LLP. In company, it is winding up procedure as per the Companies Act. Partnership is the creation of a contract. The provisions regarding maximum number of members in a partnership to be 100 is incidentally given in the Companies Act 2013. In a particular partnership, a person becomes a partner with another person in a particular adventure or undertaking. Anusuya and Shrita formed a partnership to undertake construction of a shopping complex. This partnership is called particular partnership. Partnership at will is a partnership for an indefinite period. When a partnership is continued even after the expiry of fixed term, it turns into partnership at will. A partnership firm is to be registered with registrar of firm. If a firm closes a branch or opens a branch, it should be intimated to the registrar of firms. An unregistered firm cannot file a suit to enforce a right arising from a contract in any court against any third party. Dissolution on a partner becoming of unsound mind is not called dissolution under voluntary dissolution. The liability of the partners will continue for the acts done before dissolution until public notice is given of the dissolution. Nominal partner is of two types: partner by estoppel, partner by holding out. Partner is the agent of the firm, but he is agent for the purpose of the business of the firm. Under doctrine of implied authority, a partner is empowered to bind the firm. Partners in profits share the profits of the firm. They need not have to share the losses. X and Y agree to divide the profits of a business in equal shares, but the loss, if any, is to be borne by X only. The partnership agreement lawful. Partners are not employees. A minor has to elect on his attaining majority as to whether he wants to become a partner or not. A new partner can be introduced as a partner into a firm with the consent of all existing partners. Every partner has a right to take part in the conduct of the business. In the absence of partnership agreement, to the contrary, the partner has a right to avail interest on advance. If a partner derives profit for himself from any transaction of the firm, he shall account for the profit and pay it to the firm. The liability of a partner in a firm is unlimited. Creditors of a firm can proceed against the partner jointly or severally. Professional qualification of admitting partner not required to be taken care while admit. Where a partner in a firm is adjudged insolvent, he ceases to be a partner from the date of such order of adjudication. In case of expulsion of a partner, provisions of retired partners will be applicable to expelled partner. An LLP is a hybrid between a company and a partnership. It has got a separate legal entity. It should have at least two partners, and every partner is an agent of the LLP. Every partner shall inform the LLP of any change in his name or address in form number 6 within a period of 15 days of such change. There is no minimum requirement of capital for registering a limited liability partnership. A partner can bring in his contribution in the form of movable or immovable property, or he can bring in tangible or intangible property, money or promissory note. An LLP includes even an LLP incorporated outside India. LLP should have designated partners, and minimum number of designated partners is 2, and one of such designated partners have to be resident in India. Designated partner shall be an individual. The particulars of the designated partner to be filed with the registrar within 30 days of his appointment confirmation. Designated partners can obtain DPIN, which is nothing but designated partner identification number. The liability of every designated partner shall continue even after the LLP has been dissolved. The accounts of LLP shall be audited if the turnover exceeds rupees 40 lakhs. The partners of an LLP may remove an auditor in terms of the procedure laid down in the LLP agreement. The books of accounts of LLP are required to be preserved for 8 years from the day they are made. All papers, registers, refund orders and entire correspondence regarding LLP liquidation is required to be preserved for more than 5 years from the date of liquidation. A company may apply to convert into LLP subject to a condition that the partners of the converted LLP shall comprise all shareholders and only those shareholders no one else. The LLP shall inform the concerned registrar within 15 days about the conversion and the particulars of LLP. The Act does not allow conversion from listed company into LLP. The central government may appoint an inspector to investigate the affairs of the LLP if not less than 20% of the total number of partners make an application to the central government where an LLP is not carrying on any business. For a period of 2 years or more, the registrar could remove the name of the LLP from the register maintained on limited liability partnerships.